Welcome, everybody. This is Kara Maciel and Lindsay DiSalvo from Maciel Carey, and we are here to do a webinar on the Me Too movement update, practical strategies for training, investigations, and discipline. I am Kara Maciel, and I am chair of the Labor and Employment practice here at Maciel. With me, I have my colleague Lindsay DiSalvo, and we represent employers across all industries on these issues of harassment, training, conducting internal investigations. And so this is going to be just a good hot topic today about where we are in terms of post-Me Too. We're going to talk about really framing the issue of harassment and how that has been played out from the EEOC's perspective in the last year or two. Go into some of the impacts of the Me Too movement that we have seen as a result, and then share really some practical strategies for your workplace in responding to claims of harassment and some best practices for investigating claims. So with that, I'll turn it over to Lindsay to talk about the issues of harassment.
All right. Good afternoon, everyone. As Kara said, my name is Lindsay DiSalvo, and we're first just going to go through a few slides here that show how the EEOC has looked at the issue of harassment and what we've seen as far as an increase in the charges of specifically sexual harassment as well as lawsuits brought by the EEOC. So first you'll see here, back in 2016, so before the Me Too movement actually went viral, the EEOC formed a select task force that was going to examine the issue of harassment as well as effective strategies that have been used to prevent harassment. And as a result of that task force, the EEOC published a report in June 2016 called the Select Task Force on the Study of Harassment in the Workplace. And the point of this report was to reboot workplace harassment prevention efforts. So the report was supposed to explore the different bases for harassment, what was leading to harassment, as well as some of the things that the EEOC and employers could do in the workplace to try to prevent harassment. So the report covered all forms of harassment, not just sexual harassment, although that was one aspect of it. And it also includes a number of findings that the EEOC had, as well as a number of recommendations that were aimed at the EEOC making improvements, as well as to help employers prevent harassment in the workplace, educate employees about harassment in the workplace, and then other participants in this issue. And the task force was actually originally convened in 2015 and evaluated the issue for just over 18 months in putting together this report and looking at a lot of data and speaking with different groups and different individuals to try to get information on this issue. So you'll see here, this slide shows a couple of findings from the report. The first is that workplace harassment does remain a persistent problem in the workplace. And a big part of the reason that it does continue to be a prevalent issue in the workplace is because it often goes unreported. And interestingly, in this report, they found that the least common response to harassment is to actually take some form of formal action. And this usually means the employee either doesn't report the harassment internally that they may have experienced, or those who witness harassment don't report it internally, or the victims of harassment don't proceed with filing a formal legal complaint to address the harassment. The report also found that there is a compelling business case for stopping and preventing harassment, and this kind of took two main issues, and that is first, that workplace harassment causes severe pain and suffering to the victims of the harassment. They can experience mental and physical consequences due to the harassment, and that in turn can affect how they're able to work for the employer. It can result in decreased productivity. If an employee is experiencing harassment, they're distracted and may not be as productive as they usually are. Harassment also leads to increased turnover, which again can have a significant economic impact on the employer to the extent that they have to get someone new, to the extent that they have to train someone new. And then also, if the issue isn't reported and addressed, the individual who may be perpetrating the harassment is still in the workplace and could still be creating these issues with other employees. So here, this slide shows a couple other really important findings from the Select Task Force report. The first is that leadership and accountability are critical. This is probably not surprising, but it is important, I think, in light of the Me Too movement, because we've seen that sometimes, especially for these more notable and public cases, it is leadership that is actually involved in the harassment and potentially perpetrating the harassment. So from that perspective, we've seen that it's really important that leadership is involved and held accountable as well. But the report specifically talks about the impact of culture and how workplace culture has the greatest impact on allowing harassment to either flourish or to actually prevent harassment. So if you're creating a work environment that really emphasizes civil and respectful interaction between coworkers, that's going to be more likely to foster an environment that actually prevents harassment. And then also ensuring that there are accountability systems in place so that those who engage in harassment are investigated, held responsible if it's determined that they have actually engaged in harassing behavior, and then that those who report harassment are rewarded. Employees who come forward and report harassment that they're experiencing, or bystanders who might witness harassment and taking part in reporting those and addressing those, these accountability systems are really important to foster that environment. In this same vein, it's also important to ensure that there's accountability systems in place to prevent any sort of retaliation for those who do decide to come forward and report an issue of harassment. And then the second part here, that training must change, that new approaches should be used by employers to try to prevent harassment in the workplace. And the report focused on training that is too focused on avoiding legal liability, so training that emphasizes sort of the legal standard and how to avoid being held liable for claims of harassment. And the report said that this approach isn't really that effective, that what employers need to do instead is, focus training on creating a civil and respectful work environment as opposed to the legal standard and avoiding legal liability. So here we have a quick poll. Those of you who are using your computers, have access to your computers, should be able to participate in this poll. And I'll give just a couple, or just like a minute here to respond. But the question is, has your company received an increase in EEOC charges or complaints since the Me Too movement began? And this is a new tool for us, so I'm hoping that this works, but we'll check the results in just a couple seconds. I'm seeing just one or two more trickle in, so we'll wait just a little longer. Okay, so you can see by these results here, a majority of people said that they're still not experiencing an increase in the EEOC charges or complaints, but it looks like almost 30%, so 1/3 of those who participated have actually seen an increase in these charges, and that reflects what we're actually seeing from the EEOC's most recent statistics on the charges as well as lawsuits that have actually been brought by the EEOC. So in fiscal year 2018, there was about a 12% increase in the amount of charges that were filed with the EEOC that alleged at least one claim of sexual harassment. So some of these charges probably also included other claims maybe related to discrimination in the workplace, but about 7,609 charges filed did include a claim for sexual harassment. And this reflects, the greater discourse that's ongoing about harassment, particularly sexual harassment in the workplace related to the Me Too movement. Also in fiscal year 2018, we saw a 50% increase in sexual harassment lawsuits brought by the EEOC. So the EEOC has the ability, based on charges that are filed, to bring a lawsuit on behalf of an employee or a group of employees, and it did so 66 times in fiscal year 2018 for harassment lawsuits generally, and 41 of those lawsuits include the allegations of sexual harassment. So it's a pretty significant increase in the EEOC's activity on this front. And then finally, you'll see in fiscal year 2018, the EEOC recovered nearly $70 million for victims of sexual harassment through both these lawsuits that they're bringing as well as through the administrative enforcement process. And that's actually up from $47.5 million in fiscal year 2017. So again, a statistic showing the financial impact that these types of claims can have on employers. So now we'll spend a little time going through the major impacts of the Me Too movement that we've seen in the work environment. So first, arbitration agreements. Back in 2018, in a case called Epic Systems, the Supreme Court determined that pursuant to the Federal Arbitration Act, employers could require employees to waive their right to file certain types of claims in court. And that case actually focused specifically on collective and class actions, and require that those claims be resolved through arbitration. With this decision, arbitration agreements became even more attractive for employers, although a lot of employers were already using arbitration agreements for this purpose. And these types of agreements were often including arbitration of discrimination and harassment claims. And arbitration has many benefits for both the employer and the employee, such as providing a neutral and confidential process to resolve issues in the workplace, and also to prevent the cost from being so high as it can be through the litigation process. However, in the time of the Me Too movement, employers have started to be criticized for including sexual harassment claims in their mandatory arbitration policy, as this permits settlement of those types of claims in a way that maybe the public won't be aware of the outcome or the fact that allegations of harassment have even been made. Thus, some employers have started to move away from arbitration of these types of claims, of sexual harassment claims, or at least mandating that employees arbitrate those claims. So they're starting to change their agreements to allow the employee to choose whether they want to arbitrate claims of sexual harassment or whether they'd rather pursue them in court. One example is a large tech company, after it experienced some protests from some of its employees, did go ahead and change its arbitration agreement so that it was no longer requiring that arbitration occurred for claims of sexual harassment. And in connection with that, it also rolled out some major changes in the way that it was handling harassment complaints. It created a single dedicated site through which employees could actually make claims of sexual harassment, and it also offered extra care and resources to employees who complained of sexual harassment, such as counseling services as well as career support. So far, this change has been mostly focused on claims of sexual harassment, which makes sense in light of the Me Too movement. The emphasis really has been on sexual harassment at this point, but it could be, with this trend that eventually it does move to including general claims of harassment like race-based or religion-based harassment or claims of discrimination. Another area where we've seen an impact from the Me Too movement is in executive agreements and the hiring of executive-level employees. Because an executive represents the face of the company, when they are accused of sexual harassment or sexual misconduct, or have actually been found to engage in sexual harassment or sexual misconduct, it often causes significant reputational harm to the company and can also lead to significant financial harm to the company. Because of this reason, companies have started to take action to deter such behavior by changing some aspects of executive agreements, as well as sort of changing their procedure for hiring executives. A few of the things that we've seen, you can see on this slide. Some employers have started to revise the definition of cause in their executive agreements to more clearly allow them to avoid paying a severance package to an executive that is terminated and has engaged in sexual harassment. So making it more clear in the language of the executive agreement that this type of behavior will exclude the person from their ability to obtain a severance package upon separation from the company. Some employers have also been updating their compensation recovery policies to provide a clawback or forfeiture provision so that previously paid compensation can be taken back if an executive engages in sexual harassment. And then we've also seen some companies asking newly hired executives to include an affirmative representation that they haven't been the subject of sexual harassment claim and that they otherwise haven't engaged in sexual harassment or other sexual misconduct. In addition, we've seen a shift in the area of mergers and acquisitions related to a similar focus. You see here language from a merger contract. This language is actually directly from a significant merger with a takeover of Athena Health. And you'll see from this language here that Athena Health had to actually affirm that, to its knowledge, there have been no allegations of sexual harassment against any current director or any employee at the senior vice president level or above in the last 5 years. So a pretty significant thing to require a company to do related to a merger. And then in the realm of social due diligence, companies have started looking into companies that they may be considered merging with or purchasing, their history related to sexual harassment and how they've dealt with allegations of sexual harassment. They've been asking questions such as what the company has done to identify this type of issue in its workplace, when the issue has come to light, how they've addressed, how they've investigated it, or taken steps after they determine that someone has engaged in sexual misconduct or sexual harassment. And this is something that employers can actually do using online resources. Employers can review the claim history of a company before a merger occurs to see if there have been any claims of sexual harassment or sexual misconduct in the last few years. There's also certain websites where companies can review how former employees or current employees may be reviewing the company, and specifically, whether any sort of harassment or sexual harassment has been an issue at the company. So aside from changes in employment agreements, we've also actually seen some changes in the law related to the Me Too movement, and after the Me Too movement sort of rose in popularity back at the end of 2017. So this slide talks about changes in the federal law. And back in the summer of 2017, the Trump administration had suspended an equal pay rule that was initiated by the Obama administration that would have required certain employers to report pay by race and gender. But then in December 2018, so after the Me Too movement rose in popularity, back at the end of 2017 into 2018, President Trump did sign into law a new tax bill, which in part revised the Internal Revenue Code to include something that has been referred to as the Harvey Weinstein provision. And basically what this provision does is it prohibits employers from taking a tax deduction for any settlement or other payments related to the settlement of a sexual harassment claim if the settlement did include a non-disclosure agreement. So because of this change in the Internal Revenue Code, some employers will now face a challenging dilemma. The employers can forego the confidentiality clause, they can forego using a non-disclosure agreement and actually get the tax deduction, but in that case, they could potentially, be opening themselves up to public knowledge of sexual harassment or sexual misconduct that has occurred, or they can go ahead and include a non-disclosure agreement as part of the settlement, but then have to pay the tax and not get any sort of deduction for that payment. And then at the state level, we're actually seeing the most significant changes since the Me Too movement went viral back at the end of 2017. So you'll see the first bullet here, over 125 pieces of legislation were introduced, and that was just in the first half of 2018. And 32 states at that time did introduce pieces of legislation that would address how sexual harassment is treated and dealt with in the workplace. This slide shows both New York and California, some provisions of their laws. So both New York and California have adopted laws that impact the way that sexual harassment is treated in the workplace. You'll see both New York and California include provisions that address non-disclosure agreements. In New York, an employer cannot include a non-disclosure agreement unless the employee consents. You'll see in California that non-disclosure agreements related to sexual harassment claims are not to be used. And then also there are provisions of these laws that affect training and require certain types of training. So in New York, employers are required to complete sexual harassment training for their current employees by October of this year. So that's coming up, in only around 7 months from now. And then once that initial training has been completed, the law does require that employees are retrained on an annual basis. In California, the law requires that both non-supervisory and supervisory employees receive sexual harassment training by January 2020. For non-supervisory employees, this requires about an hour of training. And then for supervisory employees, employers are required to do at least 2 hours of training, which makes sense because supervisory employees will generally, they'll receive the general harassment training and then on top of that be trained on how they as supervisors and managers actually have to respond to complaints of sexual harassment or observing sexual harassment occurring in the workplace. Like New York and California, states such as Vermont, Washington, Maryland, and Tennessee now prohibit employment agreements that prevent an employee from exposing sexual harassment or disclosing sexual harassment. And some of these states, Maryland, Delaware, Oregon, have also passed legislation that requires certain types of sexual harassment training be provided to employees in the workplace. So in addition to what would generally be viewed as sort of more positive impacts of the Me Too movement, there have also been some pretty negative and unintended consequences. From what we've seen, some companies have responded to what they believe to be vulnerable situations that could lead to actual sexual harassment occurring or allegations of harassment occurring by limiting the contact between male executives and female employees. And this can be really problematic for two main reasons. First, men still tend to fill a lot of the highest positions in companies throughout this country, and men tend to fill sort of the highest positions in these companies. So to the extent that they are limited in being able to mentor female employees, that also sort of creates a barrier to a female employee's ability to rise up in the company and potentially take over those types of executive positions. Women often tend to be actually in greater need of these types of mentorships to really be able to get a foothold and also have access to the highest positions in the company. And then second, this could be illegal sex discrimination. So under Title VII and under state anti-discrimination laws, employers are prohibited from treating employees differently based on certain categories, including sex. So to the extent that female employees are missing out on opportunities in a company due to the fact that they are not, permitted to be mentored by male executives, this could create an issue of discrimination in the work environment. So with that, I will turn it over to Kara to talk a little bit about our recommendations for strategies in your workplace to address the issue of sexual harassment.
Okay, great. Thanks, Lindsay. Yeah, that was a good summary of the first half. And the latter half of the webinar, we're just going to be talking about things that hopefully you all already know and are implementing, or new things to consider when implementing and rolling out harassment prevention strategies. So, the first thing that's really important is making sure that you have a clear anti-harassment policy. And the reason this is really important from a legal perspective is because, as many of you may know, if the Supreme Court in the 1980s passed a decision that said if a company has a policy, an anti-harassment policy, that is circulated to employees, that advises employees on how they can complain internally about harassment issues, and the employer follows through on that complaint procedure and investigates and remedies the harassment, the employer cannot be held liable. They can use this policy and the complaint procedure as an affirmative defense to any claims of harassment. So the first step of being able to use that affirmative defense is having a clear harassment policy in place. You want to make sure that it is disseminated to all your employees, whether that's in your handbook or as a standalone document, or even someplace on your intranet if you circulate things electronically. It needs to be accessible. It's one of those policies that should be reviewed and easily identifiable and retrievable for employees so they know where it is and how to reference it. It really should be written in clear, simple language. I think there's a lot of legal components that we want to include in a harassment policy, but if employees can't understand it, they're not going to be able to take advantage of it. And I also think, depending on the nature of your workforce, because this is such an important policy to have, you might want to consider having it translated into Spanish or some other language if you have a majority of your workforce who speak another language. There's certainly no necessarily legal requirement to have it translated, but we are having many clients inquire if they have a population, for example, that speaks Spanish, they will translate that policy even if they don't translate other policies from the handbook. In this policy, you want to explain in clear language what harassment is, how it should be reported, what you're going to be doing to investigate, and that discipline may occur or that some remedies will occur to make sure that any allegations of harassment stop and won't continue. Those are really the four key components of each harassment policy. And you want to make sure that in the investigation process you explain who it needs to be reported to, how you're going to investigate it, that you will investigate it promptly and thoroughly. Talk about confidentiality, that you will try and maintain confidentiality, but confidentiality cannot be guaranteed. And again, that you will take swift action if any allegations are found to have merit. You also want to talk about making sure that employees understand that if they do report or participate in an investigation under a complaint process, that they will be protected from retaliation. Retaliation, and we'll talk about, is a really key element of training in harassment, because so many people feel and fear retaliation, which is one of the major reasons why harassment isn't often reported enough in the workplace. And so you want to make sure that your policies clearly outlines that employees will be free from any type of retaliation for reporting or participating in a harassment investigation. And then we've been having a lot of dialogue about a zero tolerance policy. I think those were very popular several years ago. They wanted to show a strong force that this company doesn't tolerate harassment and it's going to be zero tolerance. I think the downside to that is, and we'll talk about this in a few slides, there's a lot of gray area when it comes to harassment. You might have an investigation that certainly is not conduct that leads to the legal definition of harassment, and therefore doesn't necessarily require or mandate termination. But you may have conduct that is not cool, or it's just not civil, it's not respectful, it doesn't uphold the values of your organization. And the question is that something that is definitely terminable? And if you have a zero tolerance policy, you might be forced to make a termination decision where some other remedy that's more proportionate to the conduct would be appropriate. So just think about whether you want to have a zero tolerance policy in your organization, and think about the ramifications of that. The other thing that we find, and this is still really important to remind everyone and to remind your employees, is that harassment doesn't just occur during the workday in the office setting. It can occur outside of work hours. So anything with respect to holiday parties or sponsored parties or social events, the Friday happy hour, at the bar downstairs, things can happen in those more relaxed settings. People feel more comfortable, they're more at ease, and you might still have potential harassment claims showing out from that. That's also true if you have employees who travel, whether it's to conferences or shows or other travel meetings. A lot of the issues that I've been investigating in the last year often do come from complaints that are made while people are traveling, in hotel rooms, in hotel bars, and just be mindful of that. And certainly, social media plays a large role as well. The text messaging, WhatsApp app, the different types of communication devices that employees now have with each other also is a ripe area for potential harassment issues. And just so, as again a reminder, I mentioned this at the beginning, but just so everyone understands, when can you be liable for harassment? And a company is vicariously liable, which means you don't have the option of having that affirmative defense if the harassment is done by a supervisor or other management representative. And that's going to be important, and that's why training managers is such an important part of having a good prevention program in place, because they need to understand that it's their behavior that can trigger liability on the part of the company, and their actions are attributed directly to the company, regardless of HR knows about it or if other managers know about it. Their status as a manager or management representative is what triggers that liability. And as I mentioned, if it does not result in a tangible adverse employment action, meaning that doesn't result in someone being terminated, then you do have that right to assert this affirmative defense if you can show that you exercised reasonable care to correct and prevent the harassment, which is why having that policy against harassment is so important, why you have multiple avenues to report harassment. And you can show that the employee knew about the policy, knew about the complaint procedure, and failed to take advantage of that. And that's what we call the Farrer-Eller affirmative defense. And we get a lot of questions about coworkers, right? So what happens if it's coworker-coworker harassment? Is that any different? And employers can still be liable for harassment by non-supervisors or third parties who are vendors or suppliers, people delivering items to the company, only if management knew or should have known about the harassment and failed to do anything about it. So it's a little bit of a lower burden, but still you need to, again, really make sure your managers are well trained, because they need to report what they see from third parties or what they see from coworkers if in order for you to be aware of it and for you to correct it. So it's really important that management understand that you can't keep things secret, even if it's happening at the coworker to coworker level, and you still have a duty to promptly investigate it. And not to condone or ignore the harassment. Coworkers should feel empowered to tell people to stop behavior, that they should feel empowered. We're going to talk about bystander intervention in a few minutes, but you should empower your employees to confront the issues if they feel comfortable, and certainly be able to bring it to management's attention, HR's attention. The second prong to a good prevention program, and we talk about this with the policy, is making sure that you have a multifaceted complaint procedure, right? So your complaint procedure and your policy should clearly inform, who, what, when, and how this behavior should be reported to. So you want to identify who should report. Explain and train your employees that the person who feels the harassing behavior should absolutely report, and or employees who witness harassment. So if you see employees, coworkers, they should feel empowered. They're not legally required to report it, but they should feel empowered to report harassment, because that's the only way management can foster a culture of civility and foster a workplace culture where harassment won't be tolerated. You want to designate in your policy who they can report to. Traditionally, they report it to HR. HR is the organization and then what investigate it. But you might want to have other avenues as well. We've heard some companies do a 1-800 number, an anonymous tip line. Sometimes we've got organizations now, there's lots of them that do kind of an online reporting, and that company will sort of be the mediator between the company and the employee anonymously to investigate. You want to talk about making sure that people can report things a variety of ways. It doesn't necessarily have to be in person. It can be in writing. It can be anonymously. It could be by email. And then importantly, that they understand they have to report it promptly. There's no way that you as a company can investigate something thoroughly if you don't know that it's happening. And so people need to not delay in reporting of this behavior, particularly as it gets more serious and if people really are feeling like it's impacting their day-to-day working conditions. And then what managers need to understand is they have to take immediate action to address the harassment if they are the recipient of a complaint. Even if they're not traditionally the manager in HR who would investigate, they need to pass that complaint along to the appropriate individual in the organization and take steps to make sure that the employee understands that, yes, I've received your complaint. Thank you for bringing it to my attention. I'm bound as a manager to bring it to someone else's attention, but rest assured that we're going to take all steps necessary to investigate it and bring this to resolution. So I talked about bystander intervention. This is something else that the EEOC talked about in its report, and something that more employers are really starting to incorporate into their training of non-supervisory employees. And this is making sure that employees and coworkers feel comfortable and empowered to intervene if they feel that they are witnessing harassment. A lot of times they're not comfortable observing harassment even when they're not the direct victims. Even if they feel like it's their coworkers, it's happening to somebody else, it still has a negative effect on them. And so a lot of times people don't know what to do in that situation. Maybe the coworker doesn't want them to report it, or they feel like they can handle it themselves. But having bystander intervention training really, again, teaches employees how to recognize problematic behaviors, things that often as a coworker they're not necessarily trained like a manager would be. It motivates them, empowers them to take action. It teaches them some intervention skills and gives them resources to support how they can intervene. And it ultimately creates a sense of responsibility for them to do something rather than just simply stand by. And this goes back to the culture issue that Lindsay was talking about earlier and the accountability of leadership. You want to make sure you're creating a culture in your organization that you lead from the top. And you're reinforcing that leadership, not just from the top, but from the bottom, middle, everywhere. Everywhere is that culture. And once you have that culture embedded in your workplace, I think we'll find that those claims and those concerns and those internal complaints will really start to decrease. Once, of course, you receive a complaint, you must do a prompt investigation. That is an essential element of the affirmative defense. And so what you need to do is you need to establish a procedure how claims of harassment will be investigated. Who does the investigation? Or is it automatically directed to HR? Within HR, who is trained to conduct an investigation? Is it someone who deals with employee relations? That person might be different than the person who handles payroll and benefits issues. Whoever is assigned within the organization to lead harassment investigations, strongly recommend that they be trained specifically on how to do that. Because if it ever leads to litigation, the thoroughness and the promptness of the investigation will be questioned at a deposition or in litigation. That's often a way that plaintiff lawyers try to attack the investigation to claim that it wasn't done thoroughly. So you want to make sure they're done prompt, they're done objectively. You want to include interviews, at least of the complaining interview, usually the alleged harasser, and any other witnesses who may be identified. And the investigation is going to flow. It's really going to depend on the nature of the facts. There might have a situation where you don't need to interview the alleged harasser because you have evidence from elsewhere. Maybe it's emails or text messages or others that you don't need to necessarily interview the harasser because it might not bring new facts to date. But anyway, it really is a very fluid investigation. You want to try and keep it as confidential as possible, although confidentiality cannot be guaranteed. Right? There was a lot of discussion about confidentiality from the NLRB, but really what you want to be able to tell the employee is, look, I will maintain confidentiality as much as possible, but it may be that I need to interview a witness and get some more information. And so the goal is to keep it as tightly controlled. Certainly you want to make sure that whoever is conducting the investigation, you're keeping contemporaneous notes, what you've done, who you've interviewed, what documents you've received, really the step-by-step process of the investigation. And depending on the nature of that investigation, those notes, if you go to litigation, may be discoverable. So you could keep them privileged through an attorney-client privilege relationship, although know that a lot of times some of that documentation may have to be disclosed. So you want to have training and understanding about what to include and what not to include to make sure that that documentation is as credible and as objective as possible. And then depending, of course, on the outcome of your investigation, you may have disciplinary action. You may need to follow up with the employees. You may need to do some additional information. But no matter what, you want to make sure that there's absolutely no retaliation that is taken following the investigation. And what I understand is, and what happens when people call me often is, okay, I've done this investigation. Here's what I found. What do I do next? And I really kind of like this, red, yellow, green thinking, because if you've done your investigation and you've found conduct that reaches the level of illegal harassment, what the legal definition of harassment is, and you found that it's occurred, I think the decision there is fairly easy, right? Usually it's a termination decision at that point. That's a relatively easy one. And then on the green side, if you found, look, I haven't seen any evidence of the allegations being credible, I don't feel like there's anything happening here, you can quickly kind of make that easy decision as well. But it's this yellow phase. It's this, I found inappropriate behavior, not respectful behavior, behavior that really doesn't live up to the core values of our organization. What do I do next? And that's a lot of times where you need to be creative, and that's where the zero tolerance policy often prevents you from coming up with more creative solutions as to what people can do. And I'm not saying that you don't take action in this situation, because I think that's really important to create a workplace of civility. I think, again, that's accountability, leadership from the top to show that you care about this behavior. Even if it doesn't necessarily qualify as illegal, it still is violative of your company's policies and culture and what you want to do next. So it really does depend on the situation. It depends on the conduct, and it really also depends on what you have done in the past and what kind of values you want to set going forward. So I've got another poll here. Let's see. This one let's see. Did I get this? It looks like that was the same one. So that didn't work. All right, well, let's skip to this one. What I wanted to ask people was if you provide any training. Let me go to this slide. Okay, so it looks like it came up here. Do you conduct any non-supervisory harassment training? And here it's yes, we did it in 2018. No, we haven't done it in the past year. Or no, but we do have training planned. I give everybody a minute or two to answer. We have a few more responses coming in. Lindsay, did you just hit skip to results, or did you close the poll?
I think I did close the poll, so I think it does it automatically if you close the poll. Okay.
All right. So a majority of the people on the call did do non-supervisory harassment training in 2018. That's good news. About 20% have not done it in the past year, and about another quarter of the group do have training planned. So I hope that for those on the call, the webinar, the training that you did last year was effective and helpful. But I really do think it's an important part that employers should be providing regular anti-harassment training to all employees, not just to managers. And as we saw from states, many states are starting to take that approach as well. And so if you are in a state where you're required to have harassment training in the near future, that is definitely something you want to start implementing. And here are some recommended elements of a training that we suggest. Talking about what is respectful conduct versus unacceptable behavior, what is legal versus not legal. Really trying to make the non-supervisory employee training very interactive. You want to have the employees be able to talk to each other, engage in scenarios, potentially maybe talking about how some uncomfortable situations come up and how they would handle it. So really try and find a way that they can apply what they're learning and hearing in the training and ask questions, and do it maybe in small group settings. So we really like to incorporate the interactive element to our training. I also think it's important to cater to your specific industry and work environment. What happens in a restaurant is very different than what happens in an office setting. And so you want to be sensitive to whether you're in a unionized or non-unionized workplace. How those different elements come into place and what might be different or unique to your industry that other work environments not have. You want to implement illustrative, realistic examples that, again, is tailored to your work environment. And of course then reviewing your policy. I would hand out the policy at the training. I would remind people where it's located. I would, again, reiterate where they can see the complaint procedure so that there's no question that you haven't made employees aware of the policy, of what's acceptable behavior, and how they can complain if they need to in order to take advantage of that training. And then of course, we also suggest providing management training in addition. And that might be separate. It usually is a little bit of a separate training from your non-supervisory training. And that's because managers have different roles and responsibilities. And they are really the ones, your boots on the ground individuals who need to identify and prevent and address harassment. If they engage in harassment, they are the ones that legally bind the company and make the company liable. And so you want to make sure that they understand what their obligations are and what their roles and responsibilities are in protecting the company from addressing and preventing harassment. You want to make sure that managers understand how they can respond to complaints, even if they are not necessarily the designated individual who will investigate. They need to understand how to receive it, how to respond, and understand generally what harassment is so that they can observe, if they observe it, they can report it. You want to make sure that they understand how to receive the complaint and how to respond to events of behavior. And again, our training, our management training, does include those workplace-specific examples that makes it interactive so that managers can really understand, okay, if I'm in this situation, this is how I would respond. We talked earlier about the issue of retaliation, and that, just like discrimination and harassment, it is a separate claim that could lead to liability for a company if there is retaliation against an employee for engaging in quote-unquote protected activity. And protected activity is raising a complaint of discrimination internally. Retaliation is protected both by Title VII and the state equivalent anti-discrimination law. And what we often see when individuals file EEOC charges is they may check the box for sex discrimination or sex harassment. They will also check the box for retaliation. And more times than not, the EEOC will investigate and dismiss the underlying discrimination or harassment charge, but they may find more evidence of retaliation because the legal standard of retaliation is a little bit easier to establish than it is of harassment. And so you want to make sure you are discussing and protecting against retaliation in the workplace. The legal standard specifically is, would this behavior dissuade a reasonable employee from reporting issues to the employer? So it's not necessarily the concrete adverse actions like hiring or firing or terminating or disciplining or reducing someone's pay, but it could be something as subtle as changing work schedules and shifts, or relocating someone's offices, or changing someone's supervisor. Those maybe subtle shifts in terms and conditions of employment could be considered retaliatory behavior if a court would find that it would dissuade a reasonable employee from reporting the issues to the employer. So the last slide before we open it up for questions is really just some general best practices, and this is just a reiteration of what we've talked about today. You want to ensure that your harassment policies and training are supported and enforced at the highest levels of your organization for that leadership and accountability. You want to regularly review the effectiveness and the content of your policies in your training. What worked 2 years ago or 5 years ago might not work today in the workplace, particularly in light of the Me Too movement. So you really want to refresh those policies, take them off the shelf, make sure they're updated, and make sure your training is updated and legally compliant with state law to the extent that it's mandated. You want to focus your training on creating a respectful and collaborative workplace versus just using it as a defense for legal standards. And I think that's going to be much more effective in getting it across to your employee base, is making sure you're doing this shift in the way that you're delivering the training to focus on workplace civility. Think about incorporating issues such as unconscious bias or cultural sensitivity in your training. That's something that we have done as well, and we've started to see some issues in the news about unconscious bias, and I think that's a really important element for employees to understand how to witness and observe and be cognizant that that still happens in today. And then, of course, emphasize the responsibility of every employee at every level within your organization to report harassment and report it. That's both in your policy and emphasized in your training. So that's our webinar for today. If you have any questions or want more information, please visit our blog. We regularly write about these issues and other trending topics in HR and employment, so please check that out. And then this is a series of our 2019 Labor and Employment webinars, and you'll see we've got several coming up. So if any of these are of interest to you, please sign up or email me and we can get you signed up for the upcoming series. And Lindsay, in the meantime, do you want to take any questions that may have come up?
I do see that we have one question so far, and it is, what is the definition of supervisor with regard to this law? And I think that came up during the discussion of the state law. I think California specifically, the supervisory versus non-supervisory training. And it says, in the airlines, union members often retain many of the supervisory responsibilities except hiring and firing. So in response to that question, if it is in reference to the California state law, I can tell you that the guidance provided by the California department that enforces this particular law, this law requiring training on sexual harassment, they say that a supervisor is anyone with authority to hire, fire, make assignments, transfer, and discipline or reward employees. So pretty broad definition of supervisor and who could constitute a supervisor. They also say that a supervisor is anyone with authority to effectively recommend these same sorts of actions using their own independent judgment. So it can be people who have a say in recommending whether someone be hired or fired or disciplined for certain conduct, but it doesn't necessarily need to be someone who can actually take action on that particular recommendation.
Thanks, Lindsay. If anyone else has any other questions, feel free to type it into the Q&A, and we'll try and address it with the last few minutes that we have. But okay, we're getting some questions. It says, what is the best resource for getting help in establishing a complaint procedure investigation process for human resources person who's responsible for these procedures? We have some resources in terms of establishing a complaint procedure. We also have in our archive, last year we did a webinar on the investigation process, conducting internal investigations. I'd be happy to share that. But SHRM might also have some resources. It's really important that you have this complaint procedure and investigation process for human resources established. Another question, is an employee able to receive monetary recourse if they file a claim with the EEOC, or is the EEOC the only ones allowed to collect monetary recourse? Great question. Yes, if someone files a charge with the EEOC and the EEOC investigates it, during the investigation process, it's really just a neutral fact-finding role. But if at the end they find that there was cause for discrimination, or during the course of the investigation, the EEOC and the employee want to settle the charge with the employee is able to collect monetary recovery. And that's usually in the form of lost wages or what economic harm the employee has suffered. So if it's in the situation of a termination and the employee got a job a month later, it could be just the back wages between the time of the termination and the new employment. So it really varies, but generally it is the employee is able to recover. If the EEOC chooses to litigate the case, as Lindsay indicated, there was a 50% rise. There are also civil penalties that could be assessed against the employer that would go to the EEOC. So it can be both. Did you want to take this next question under the California training requirements?
I mean, yeah, I don't know that there is a definite response to that at this point. I think more and more guidance will probably come out as this law is in effect for a longer period of time. And I'll say the specific question is under the CA training requirements, it states we need to train on what to do if the supervisor is personally accused of harassment. Any comments on what this means? I mean, I think it could mean a few different things. I think probably as part of supervisory training, making sure that supervisors understand their role, the fact that if they are personally accused of harassing conduct, what that could mean for the company and the company's liability. If they are the ones that actually receive the complaint, that the employee comes to them and tells them that they feel that their supervisor is engaging in harassing conduct, that they are still obligated, even if the complaint is made against them, to follow the same procedures as they would if they received a complaint about another supervisor. Whatever, the process is from there, whether it's going to HR, even if the supervisor receives a complaint, that they are the ones that are, engaging in sexual harassment or sexual misconduct, that they still need to report maybe to HR and, engage in the investigation process like they would with any other complaint.
Another question has come in that's asked, in terms of requesting an executive to affirm that they have not been the subject of a sexual harassment claim, how can a company confirm? Well, I'm not sure there is an exact science to that. I think probably Googling, if there's possible seeing, public records, a lawsuit or something that might have come out. Certainly reference checking. I know a lot of employers, provide references that only says, name, date, dates of employment. I always like suggesting that they ask the question, is the employee eligible for rehire? And if they say yes or no, that's indicative. But you're unlikely to get a former employer to provide an official reference that would include a harassment claim. So it's hard to confirm. I think you can try and do the best you can being investigating, but you also really want to just trust that the executive is telling you the truth, and if it comes to light later that something happened in the past, that's certainly grounds for discipline in the future.
Right, and I would just add, to the extent that it's actually part of the executive agreement, and the agreement is established contingent on them making this accurate representation. I mean, I think the agreement would no longer stand if it turned out that they were not being honest in stating that they have not had prior misconduct.
Okay, well, if anyone has any other questions, we're happy to stay on a little bit longer. Otherwise, you have our contact information here, and we will be sharing the slides. So if anyone wants to contact either Lindsay or myself after the presentation with specific questions, we are happy to answer them. I appreciate everyone's time and particularly everyone's patience as we struggled with our technical issues at the very beginning, but hope everybody found this webinar useful and look forward to future webinars. Thank you.